Justice Madden, did you want to say something?
Yes, as to motions in limine, after doing my first few trials where I learned that of the 20 or 30 motions that were filed, the plaintiff and one or two remaining defendants were able to resolve about 99.9% of them. I now order that any motions in limine, you need to discuss the issues with your adversary to see if it can be resolved. And I think that was pursuant to a motion you made before me, Mr. Long. However, there are issues in which I think motions in limine are proper. In a recent trial, there were two motions in limine regarding motions to preclude certain witnesses from testifying, one made by the plaintiff and one made by the defendant. And I think under those two circumstances, they were both significant issues and that the motions in limine were proper.
Justice Friedman.
Just to follow up on that point, a lot of those motions to preclude witnesses in an established tort like asbestos are motions that have been made over and over again. For example, the motions in limine would traditionally include a motion to preclude state-of-the-art witnesses, or if more nuanced, to preclude state-of-the-art witnesses from giving conclusions about a particular defendant's liability. I don't think there's a judge doing this in New York State who would preclude state-of-the-art testimony, or one who would allow a witness to give the ultimate conclusions in the case. So I think that limiting written motions in limine has been very useful. I also think there's a lot of value in consistency in rulings, to get back to that point, but also value for the trial judges to be able to decide the motions in limine. But I think that we could do better at coordinating than we have. And to that end, I know that Justice Heitler is working to put together a book of rulings which should be very helpful. I always ask for other judges' rulings before I rule on a motion in limine. I ask the counsel to bring it in, and counsel in this litigation are extraordinarily well prepared and well organized, and they're usually able to bring in those rulings. But if the court itself has a book of the rulings on different issues, it should be very useful for all of us.
I agree. Ken?
I just want to, the many mistakes I made during my career on the bench, one of them was not to have a written order for every motion in limine that was granted, and that being served on the witness that was affected by that. And in my particular case, it was a police officer saying, well, what were the indicia of occupation of the apartment? There was a bill, there were some letters, and then anything else, the DA says, and the officer says, well, there was the gun, but I thought we weren't supposed to talk about that. But, Lisa, written orders in limine so you can enforce.
Lisa, do you have any comments?
Not on the motions in limine, okay. But if we could move
I'm going to move to the next topic. I'm sorry, yes. Sure.
Sorry to catch your name, but on consistency of rulings, are you suggesting consistency so you would know rulings in other jurisdictions, or just focused on New York state or federal rulings?
Well, I hadn't really thought outside the jurisdiction, but it would not be unwelcome to see rulings from other jurisdictions. I think it's actually a very good idea.
I agree with you.
I'll get right on that.
Well, talk to Justice Heitler.